Imagine trying to uphold fundamental human rights, not just, on paper, but in places, in regions really scarred by decades of conflict, facing systemic violence, deep-seated injustice. It's a challenge that really makes you think, doesn't it, about
Yeah.
the limits and maybe the possibilities of protecting these rights.
It absolutely does. And for anyone studying this or just curious about how the world tries to tackle these huge problems regionally, well, today we're taking a deep dive into one specific system, the Inter-American System for the Protection of Human Rights.
Right, and this system, it's one of the big three regional frameworks, isn't it, alongside the European and African systems. But it seems to operate in a pretty unique context, often dealing with histories of just massive, large-scale violations. That presents different hurdles, I imagine.
That's precisely it. The context is key. And for this deep dive, we're drawing all our insights, our analysis from key chapter covering this exact topic. It's a recourse made available through the online library.
Yeah, and we really want to thank the University of London for providing access to this material. It's the foundation for our discussion today. And just to be clear, this deep dive is intended purely for educational purposes, really to help you unpack this crucial area of international human rights law.
Absolutely. And this deep dive is brought to you by Sinorbit Academy, Sri Lanka. So, our goal today, our mission, is to sort of guide you through this material, help you understand the architecture, the structure of the system, the foundational documents, what rights do they actually protect, and the roles, the powers of its main institutions.
That's a commission in the court, right?
Exactly, the Commission and the Court. And maybe most importantly, how they've actually tried to grapple with these incredibly difficult real-world problems. We'll
Yeah.
flag key concepts, important cases, facts, maybe repeat them a bit where it's helpful, just so you feel really well-informed and hopefully ready for your studies.
Okay, sounds like a plan. So where do we start? The origins.
Let's begin right there. Let's explore the origins. It wasn't something that just sprang up fully formed.
No, definitely not. You have to go back quite a way, really to the mid-19th century, wouldn't you say? These early sort of stirrings of unity movements between North and Latin American states. Things like the First Congress of American States back in 1826, though that wasn't really about human rights specifically, was it?
Not in the way we think of it now. And then later, you had meetings between 1889 1890 in Washington, which led to the Pan American Union being set up.
And those early efforts, what was their main goal?
It's important to frame that right. The initial objectives, they were very much focused on, let's say, practical cooperation. Things like boosting economic ties, finding peaceful ways to settle disputes between the countries, human rights as a central theme. That wasn't really on the table at that point.
Okay, so the big pivot towards human rights came much later then.
Significantly later, yeah, really after World War II. That global catastrophe just underscored this urgent need for international protection of human rights. And this period, this is when we see the creation of the Organization of American States, the OAS.
The OAS Charter, 1948.
Exactly. Adopted in Bogota in 1948, it set up the OAS as a regional agency working within the broader UN system, and its goals were pretty ambitious: peace and security across the hemisphere, promoting democracy, fighting poverty, resolving disputes peacefully.
And who are the original members signing up to this?
Well, a large group signed on right at the start in 48. You had Argentina, Bolivia, Brazil, Chile, Colombia, Costa Rica, Cuba, the Dominican Republic, Ecuador, El Salvador, Guatemala, Haiti, Honduras, Mexico, Nicaragua, Panama, Paraguay, Peru, the United States, Uruguay, and Venezuela, a real core group.
And it's grown since then.
Oh, yes. Over time, it's expanded quite a bit to cover most of the Americas and the Caribbean. States like Barbados and Trinidad and Tobago joined in 67, Jamaica too, and importantly, Canada joined much later in 1990, so it really became a truly hemispheric body eventually.
And alongside setting up the OAS structure, there was a key human rights document adopted right then, too.
Yes, absolutely critical. The 1948 American Declaration of the Rights and Duties of Man, the ADHR. Now, this document, it shares a lot of similarities with the Universal Declaration of Human Rights, the UDHR, which the UN adopted later that same year.
But there's a key timing difference, isn't there?
There is, and this is a really important fact, one worth remembering for exams. The American Declaration, the ADHR, was adopted in Bogota, Colombia in May 1948. It actually predates the UN's Universal Declaration by several months.
Wow, okay, so the Americas were already codifying regional rights before the global standard was finalized. That's fascinating. So they had the declaration in 48. When did the idea for actual institutions, a commission, a court, come about?
That took a bit longer. The decision to create separate bodies, the Inter-American Commission and eventually a court, was made at a meeting of foreign ministers in Santiago, Chile in 1959, so about a decade after the declaration. Then the statute for the commission was approved by the OAS Council in 1960.
And then came the big one, the American Convention on Human Rights.
Right, the American Convention on Human Rights, often called the ACHR or the Pact of San Jose. This was adopted by OAS member states in San Jose, Costa Rica in 1969. It entered into force quite a bit later, in 1978.
And why is the ACHR so important?
Well, it's crucial because it provides a much more detailed and legally binding list of civil and political rights compared to the earlier declaration. And it specifically outlines the powers and procedures for both the court and the commission. Critically, it also redefined the powers of that commission, which had already existed for 10 years.
Oh, so.
It made the commission formally a statutory organ of the OAS and gave it new, stronger powers for protecting human rights. But here's the catch. These new powers, the ones laid out in the convention itself, were only legally binding on those states that actually went ahead and ratified the convention.
Ah, okay. So ratification of the ACHR is the key step for states to be fully bound by the sort of heavier machinery of the system.
Exactly. Ratification is critical for the full force of the convention and the court's jurisdiction to apply.
And which states have taken that step? Have many ratified it?
Yes, a significant number across Latin America and the Caribbean have ratified the ACHR. Countries like Costa Rica, Colombia, Ecuador, Mexico, Peru, Argentina, Brazil, Chile, Venezuela, many others. It gives the convention system pretty substantial reach within the region.
Now, one thing that often comes up as a difference compared to, say, the European system is that states have actually withdrawn from the ACHR, denounced it.
But that's a very notable point, yes.
Mm-hmm.
While the European Convention has managed to keep all its members, despite political tensions over the years, the ACHR has seen denunciations. Trinidad and Tobago denounced it in 1998, and Venezuela did so in 2012.
Why do they do that?
Often, these denunciations were directly linked to disagreements those states had with judgments coming from the Inter-American Court. They didn't like the rulings. But it's important to understand, denouncing the ACHR, the convention, is different from denouncing the 1948 declaration.
Yeah.
To leave the declaration's framework, a state would essentially have to leave the OAS entirely, denounce the charter.
And is denouncing a human rights treaty common?
Generally speaking, in international human rights law, it's quite unusual. Possible, but not common.
Okay. And thinking about the whole hemisphere, what about the big players in North America, Canada, and the U.S.? Where do they fit into this convention system?
Right, that's another really distinctive feature and, frankly, a limitation on the system's truly universal reach across the Americas. The United States, well, they signed the American Convention, but they have never actually ratified it.
Never ratified.
Never ratified it to this day. And Canada isn't even a signatory to the convention. So what this means is, for the specific human rights regime created by the ACHR, the one overseen by the court in its contentious jurisdiction, the U.S. and Canada are, well, partial players at best. Their main human rights obligations within the OAS framework stem primarily from that earlier 1948 declaration, not the later, more powerful convention.
Okay, let's circle back to the commission for a second. You said it had these old powers even before the convention fully came into effect. What could it actually do back then?
Right. Before the convention entered into force, generally in 1978, the commission operated under its initial mandate, what we might call its old powers. These came from the OAS Charter and its own statute. Under these, the commission could examine the human rights situation in any OAS member state. It could report on really flagrant or repeated violations.
So, investigate and report.
Yeah, investigate in a sense. They could request information from governments, make recommendations. They could also conduct country visits, but crucially, they needed the state's consent for that. Initially, individual complaints, someone saying, my rights were violated, they were mostly just factored into the commission's general overview of abuses.
Not handled as individual cases.
Not really, not at first. There was a limited extension in 1965 that allowed individual abuses to be considered more specifically, maybe leading to a report. But the commission didn't have the power back then to make binding decisions against a state based just on an individual's petition.
And these old powers were the basis for those really important early country reports you mentioned earlier.
Exactly. Using these powers to report on general patterns of abuse, the commission started looking into situations in places like Cuba, the Dominican Republic, quite early on. And later, during those really tough decades of authoritarian rule and conflict in the 70s and 80s, they produced major country reports on places like Haiti.
Chile, Argentina.
Yes, Chile between 74 and 80, Uruguay in 77, Panama 78, Nicaragua 78, El Salvador 79, Argentina in 1980. And it's vital to grasp the context here. These weren't just minor issues. These were countries facing profound systematic human rights
Right.
violations. We're talking brutal dictatorships, mass arbitrary detentions, widespread torture, forced disappearances, extrajudicial killings, just on a massive scale. This landscape is starkly different from the kinds of issues the European system was typically dealing with in the 70s, which were often more about, say, refining the scope of certain rights or dealing with individual liberty cases within established democracies.
So the political environment was just fundamentally different.
Fundamentally different and far more challenging for human rights protection than in the Council of Europe system at the time, and arguably still is in many places.
So this history means the Commission kind of operates with two hats on.
Yes, that's a key peculiarity. You can think of it as the Commission having a dual mandate.
Yeah.
It has done, and still does, really significant work under its older pre-convention functions, particularly producing those influential country reports on the general human rights situation in any OAS member state, whether they've ratified the ACHR or not.
And alongside that.
Alongside that, for the states that are parties to the convention, it exercises the more specific powers granted by the ACHR. That includes processing individual petitions, alleging convention violations, and potentially referring cases onto the court.
Okay, so if we pull all these threads together, the two main documents, the Declaration and Convention, the fact that not everyone ratified the convention, the Commission's dual role, the U.S. and Canada situation, what really makes the inter-American system stand out? What are its distinctive features?
Okay, let's try and summarize the key ones. First, it's undeniably complex. It's built on these two overlapping layers, the 1948 Declaration and the 1969 Convention. This creates different levels of obligation depending on which documents a state is party to, and yeah, it can be confusing.
Right.
Second, and this is really vital, the court's power in contentious cases. That means cases where someone alleges a state violated the convention. The court's jurisdiction here is limited. It only applies to states that are party to the convention and have made a specific separate declaration saying they recognize the court's jurisdiction as binding.
So just ratifying the convention isn't enough for the court to judge you, so to speak.
Not for contentious cases, no. You need that extra step, that declaration accepting the court's compulsory jurisdiction.
Okay. What else?
Third, the Commission's job description is broader than its European equivalent. Yes, it hears individual petitions and communications from states, but it also does those big investigatory country reports on the general human rights situation in any OAS member. That's not something the main European oversight body typically does.
And the U.S.-Canada issue.
Fourth, yeah, that geographical dislocation we talked about regarding the ACHR. With the U.S. and Canada being major OAS members but not parties to the convention, the convention's system in practice functions more like a Latin American human rights system. It tends to deal mostly with issues prevalent in those nations, even though its theoretical reach covers the whole hemisphere.
Okay.
Fifth, the relationship between the Declaration and Convention is unique. The Convention doesn't replace the Declaration. It kind of amplifies the rights within it and, crucially, adds the enforcement mechanisms, the Commission's specific convention powers, and the court itself, which the Declaration lacked.
And final.
Finally, the way the system has evolved, it really reflects a pragmatic approach. It's had to adapt to deal with states where, historically, the commitment to human rights has been, let's say, inconsistent or deeply challenged by conflict and political instability. That complexity we mentioned, like the court's tiered jurisdiction, is partly a result of needing this pragmatism to get states on board over time.
Okay. Now, besides the big two, the Declaration and the Convention, the OAS system has other specific human rights treaties too, right? Addressing particular problems.
Yes, it does, which shows it tries to respond to specific regional concerns. For example, there's the Inter-American Convention on Forced Disappearance of Persons, adopted in 1994. This was a direct response to that terrible endemic practice of disappearances in Latin America, and it actually came before the similar UN convention.
That's significant.
It is. Similarly, the Inter-American Convention to Prevent and Punish Torture from 1985 also predates the Council of Europe's Torture Convention. And the OAS has adopted other treaties, too, on things like abolishing the death penalty, on asylum, rights for people with disabilities, eliminating racial discrimination, and preventing violence against women.
Are these treaties similar in structure to the ACHR?
Many of them are primarily what you might call jurisdictional treaties. Their main aim is often to get states to criminalize certain acts, like torture or disappearances, and establish jurisdiction to punish them. They're important, but maybe less focused on defining the substance of rights than the ACHR.
What about economic, social, and cultural rights? We've mostly talked about civil and political rights. Are ESC rights covered strongly?
There is an additional protocol to the ACHR specifically for economic, social, and cultural rights. It's known as the Protocol of San Salvador, adopted in 1988. It does list some rights, things like working conditions, trade union rights, social security, education, health, food, environment, culture. But it's a fairly limited list compared to, say, the big UN Covenant on Economic, Social, and Cultural Rights, the ICSCR, the European Social Charters. And maybe more importantly, the way these rights are supervised under the protocol is mostly through states submitting reports. Only two rights, trade union rights and the right to education, can potentially be brought before the Inter-American Court in a contentious case.
So they're not justiciable in the same way as the civil and political rights.
For the most part, no. That limited justiciability is a key difference. It means the real enforcement muscle of the inter-American system lies primarily with the civil and political rights framework found in the main American Convention.
Okay, so the focus and the strength really are in that main convention, the ACHR. Let's dive into that document itself in more detail then.
Absolutely. Let's look at the American Convention on Human Rights. It starts, like many treaties, with a preamble. This sets the tone, the values. It clearly roots the convention in the Americas, but it also explicitly links it to universal human rights thinking, referencing the Universal Declaration. It's like a regional expression of universal principles.
And it has this quite distinctive language, doesn't it? Talking about personal liberty, social justice, and the essential rights of man being based on attributes of the human personality.
That phrase, attributes of the human personality, yeah, it's quite striking. It suggests a kind of natural law philosophy underpinning it. The idea that these rights are inherent, they belong to people simply because they are human, they're not just granted by the state, they exist before the state.
And that philosophy helps justify the convention's role.
Exactly. It frames the convention not as imposing something alien, but as reinforcing or complementing rights that should already be protected under domestic law. It helps navigate that inherent tension between universal human rights claims and the fact that protection usually happens at the national level.
Okay, Chapter 1 of the convention then lays out the big general obligations for states parties.
Yes. And Article 1 is the absolute bedrock. Article 1.1 contains the fundamental obligation. States parties must respect the rights and freedoms in the convention, and they must guarantee their free and full exercise to all persons subject to their jurisdiction without any discrimination. Respect and guarantee, that's Article 1.
Respect and guarantee, got it.
And Article 2 builds right on that. It obliges states to take action, like passing laws or other measures, to make sure their own national legal system is aligned with the convention, to actually make these rights effective domestically.
Right, then Chapter 2 is the big list, the catalog of civil and political rights. Looks like there are quite a few articles here.
There are indeed. It's the core substance.
Okay.
Let's maybe highlight some of the key rights, especially ones that have been really central to the system's work or have some unique phrasing. Article 3, for instance.
What's Article 3?
It's the right to juridical personality. Basically, the right to be recognized everywhere as a person before the law. This is absolutely fundamental. If you're not recognized as a legal person, how can you even claim any rights? So Article 3, the right to juridical personality, remember that one.
Okay, juridical personality. Makes sense. What's next?
Article 4 is the right to life. Now, interestingly, it includes language stating that life is protected, in general, from the moment of conception. This reflects certain cultural and religious influences in the region, particularly the Catholic Church.
Does it abolish the death penalty?
No, it doesn't abolish it outright for states that still had it when they ratified, but it severely restricts it. It can only be applied for the most serious crimes by a competent court, and critically, states cannot reintroduce it if they had already abolished it. So Article 4, the right to life, with that moment of conception language.
Okay, and Article 5?
Article 5 is the right to humane treatment, sometimes called the right to personal integrity. It's about respecting a person's physical, mental, and moral integrity. This is where you find the absolute prohibition of torture and cruel, inhuman, or degrading punishment or treatment.
A core protection.
Absolutely core. And Article 5 also lays out specific due process safeguards for anyone deprived of their liberty. They have to be treated with respect for their inherent dignity. Punishment should only follow a criminal conviction. Accused people need to be kept separate from convicted people, generally. Minors need to be treated appropriately for their age. And the essential aim of punishment should be reform and social readaptation. Article 5. Humane treatment, prohibition of torture, and safeguards for detainees.
Very important. What about Article 6?
Article 6 is freedom from slavery and involuntary servitude. It uses a broad definition, including involuntary servitude, and also specifically mentioning trade and traffic in women. It prohibits forced or compulsory labor, though there are limited exceptions, like work required by a court sentence, military service, or normal civic duties. So, Article 6, freedom from slavery and forced labor. And Article 7, sounds like liberty. Exactly. Article 7 guarantees the right to personal liberty and security. Paragraph 2 is key. You can only be deprived of liberty for reasons and under conditions set out beforehand in the Constitution or law. Paragraph 3 explicitly bans arbitrary arrest or imprisonment, and importantly, detention purely for debt is prohibited.
And it connects to due process.
Yes, it links directly to due process guarantees. The right to be informed of the reasons for arrest, the right to a prompt trial or release, the right to seek release pending trial, like bail. Article 7, right to personal liberty, protection from arbitrary detention.
Then Article 8 looks like a big one, the right to a fair trial.
It is, and it's very detailed. Article 8, paragraph 1 sets out the general principle. The right to a hearing with due guarantees and within a reasonable time by a competent, independent, and impartial tribunal previously established by law. And this applies not just to criminal charges, but also to determining rights and obligations in civil, labor, fiscal, or any other area.
So it covers more than just criminal cases.
Much more, yes. Civil, administrative, labor law, it applies broadly. The core ideas are an impartial, independent court established by law and the fundamental presumption of innocence in criminal matters.
And what are the minimum guarantees it lists for criminal cases?
Article 8, paragraph 2 lists several minimum guarantees. Things like having an interpreter if you need one, being notified promptly and in detail of the charges, having adequate time and means to prepare your defense, the right to defend yourself or have legal counsel, including state-provided counsel if you can't afford it, the right to examine witnesses and present your own, the right not to be compelled to testify against yourself, and the right to appeal the judgment to a higher court. And it adds that any confession evidence is only valid if it's made without coercion of any kind. Article 8, right to a fair trial, minimum guarantees, impartial independent court, presumption of innocence.
That's comprehensive. What about Article 9?
Article 9 is freedom from ex post facto laws, the principle of legality. Basically, you can only be convicted for something that was actually a crime under the law at the time you did it. You can't be punished retroactively. Article 9, freedom from ex post facto laws.
Simple but crucial. And Article 10?
Article 10 is the right to compensation if you've been sentenced by a final judgment due to a miscarriage of justice. You can see it as linked to fair trial rights.
Okay. Then we get into a series of rights that look like classic civil liberties, privacy, expression, assembly.
Right. Articles 11 through 16 cover those fundamental freedoms. Article 11 is the right to privacy, framed in terms of protection of honor and dignity. Article 12 is freedom of conscience and religion. Article 13 covers freedom of thought and expression, which is very broad. Article 14 is an interesting one, the right of reply for anyone injured by inaccurate statements made in the media. Article 15 is the right of peaceful assembly. And Article 16 is freedom of association.
Similar to other human rights treaties.
Yes, these are core rights found in most major human rights instruments. And like elsewhere, they can be subject to limitations set by law, necessary in a democratic society for reasons like public safety, order, health, morals, or protecting the rights of others. So those are the rights to privacy, freedom of conscience, religion, freedom of thought to expression, right of assembly, and freedom of association.
What about family rights?
Article 17 addresses the rights of the family. The Convention explicitly calls the family the natural and fundamental group unit of society and says it's entitled to protection by society and the state. It includes the right to marry and raise a family, subject to domestic law conditions like age and consent. It emphasizes equality of rights and responsibilities for spouses, both during marriage and if it's dissolved. And importantly, it states that children born inside or outside of wedlock have the same rights. Article 17, rights of the family.
Then Articles 18 to 20 seem to be about identity.
Sort of, yes. Article 18 is the right to a name which builds on the right to juridical personality in Article 3. Article 19 covers the rights of the child, stating every minor child has the right to measures of protection required by their status as a minor. And Article 20 is the right to nationality. So Article 18, right to a name. Article 19, rights of the child. Article 20, right to nationality.
And then Articles 21 to 23, property, movement.
Citizen-related rights, you could say. Article 21 protects the right to property, though its use can be subordinated to the social interest as defined by law. Article 22 covers freedom of movement and residence within a state, and the right to leave any country and return to one's own. Article 23 is the right to participate in government, directly or through representatives, including voting and access to public service. Article 21, right to property. Article 22, freedom of movement, residence. Article 23, right to participate in government.
We're almost through the list. Articles 24 and 25 look important too.
Very important. Article 24 guarantees equal protection before the law. And Article 25 is the right to judicial protection, sometimes called the right to an effective remedy, or emparo. This is a really powerful right. It guarantees everyone access to a simple and prompt recourse or any other effective recourse before a competent national court or tribunal.
Recourse for what?
For protection against acts that violate their fundamental rights recognized by the Constitution, by law, or by the Convention itself. And crucially, this applies even if the violation was committed by people acting in an official capacity. It's the right to actually get into court and seek a remedy when your rights are violated. Article 24, equal protection. Article 25, right to judicial protection and effective recourse.
So Article 25 isn't just about process, it's about having a real way to get justice.
Exactly. It's not just about having rights on paper. It's the right to an effective action to make those rights real.
Okay, that covers the main civil and political rights.
Yeah.
What about Chapter 4 on suspending guarantees, derogations?
Right. Article 27 deals with this. It's absolutely crucial. It acknowledges that in exceptional circumstances, times of war, public danger, or other emergency that threatens the independence or security of the state parties, a state might need to temporarily suspend some of its obligations under the convention.
But not all obligations.
Exactly. And this is a key point, especially for your studies. Article 27 lists specific rights that are non-derogable. These are rights that a state can never suspend no matter how severe the emergency. This list represents the absolute minimum core of human rights protection under the convention.
Which rights are on that non-derogable list?
It's a significant list. Article 3, juridical personality. Article 4, right to life. Article 5, right to humane treatment. Article 6, freedom from slavery. Article 9, freedom from ex post facto laws. Article 12, freedom of conscience and religion. Article 17, rights of the family. Article 18, right to a name. Article 19, rights of the child. Article 20, right to nationality. Article 23, right to participate in government. Plus, the article says you also can't suspend the essential judicial guarantees necessary for the protection of these non-derogable rights. This list of non-derogable rights is absolutely fundamental.
That's a strong core that can never be touched. Now, what about Chapter 5? You mentioned it's unique to the American Convention, something about rights and duties.
Yes, Article 32. It's quite unusual in a human rights treaty. The first paragraph says everyone has responsibilities to their family, community, and mankind. The second says that the exercise of rights is limited by the rights of others, by the security of all, and by the just demands of the general welfare in a democratic society.
Duty to mankind. That sounds a bit vague.
It does, and terms like general welfare can be open to interpretation. But this chapter is probably best understood not as creating specific enforceable duties, but more as a kind of philosophical statement embedded within the convention. It's acknowledging that while rights are fundamental, they don't exist in a vacuum. They're necessarily balanced against the rights of others and the legitimate needs of a functioning democratic society. It sort of reinforces the specific limitation clauses already found in many of the articles we discussed.
Okay, understood. So we've covered the rights themselves. Now let's look at Part 2 of the Convention, the means of protection. Chapter 6 names the two key organs.
Right. Article 33 is simple. It identifies the two bodies established by the Convention to oversee these rights. A, the Inter-American Commission on Human Rights, and B, the Inter-American Court of Human Rights.
Let's focus on the Commission first then. Chapter 7 gets into the specifics. How is it structured? What are its main jobs?
The Commission, detailed in Chapter 7, Section 1, is made up of 7 members, Article 34. They are chosen to represent all the member states of the OAS, Article 35, but critically, they serve in their personal capacity. They're independent experts, not government representatives. They get elected by the OAS General Assembly, Article 36.
And their main function.
Article 41 states its main function very clearly: to promote respect for and defense of human rights in the region. Its powers, listed there, include making recommendations to governments, preparing studies and reports, requesting information from states, responding to inquiries, and crucially, taking action on petitions, those individual complaints we mentioned earlier under Articles 44 to 51. It also has to submit an annual report to the OAS General Assembly on the human rights situation. So the Inter-American Commission on Human Rights Its composition and functions are central.
So the commission is the body that receives complaints. Who can actually send in a petition?
Section 3 covers who has competence. Article 44 is really significant here. It allows any person or group of persons or any non-governmental entity, NGO, legally recognized in one or more OAS member states to lodge petitions with the Commission. These petitions allege that a state party to the convention has violated it.
So individuals and NGOs have direct access.
Yes, direct access to the Commission. Article 45 also allows a state party to lodge communication if it believes another state party has violated the convention, though this state-to-state mechanism is used much less often.
Okay, someone sends in a complaint. Are there conditions, hurdles they need to clear before the commission will even look at it?
Yes, Article 46 lays out key procedural requirements for admissibility. These are pretty standard in international human rights systems, though the inter-American system has some important twists. First, and this is a big one, the petitioner generally must have pursued and exhausted all the remedies available under the domestic law of the state concerned.
The exhaustion of domestic remedies rule.
Exactly. The idea is, give the national system the first chance to fix the problem. Second, the petition usually has to be lodged with the Commission within 6 months from the date the person was notified of the final judgment in their domestic case. The 6-month rule.
Okay, exhaust domestic remedies within 6 months. Anything else?
Yes. The subject matter must not be currently pending in another international investigation or settlement procedure. And for petitions from individuals or NGOs under Article 44, they can't be anonymous, and they need to contain basic identifying information. So remember, exhaustion of domestic remedies and the 6-month rule are key procedural hurdles.
But you mentioned twists or nuances. What if the domestic legal system isn't actually working properly? What if you can't exhaust remedies?
This is where the exceptions under Article 46, Paragraph 2 become absolutely critical. These exceptions are vital, especially given the history in some parts of the region with ineffective or compromised judiciaries. The exhaustion requirement does not apply if A, the domestic law of the state doesn't actually provide due process for protecting the right that was allegedly violated, or B, the person alleging the violation was denied access to the domestic remedies or was actively prevented from exhausting them, or C, there has been an unwarranted delay in reaching a final judgment under the domestic remedies.
So if the system is broken or blocked, you don't have to keep banging your head against the wall.
Essentially, yes. These exceptions are crucial gateways. They allow people to access the international system when the national system has failed them or is effectively closed off. Remember those exceptions to the domestic remedies rule? They are very important in practice.
Okay, let's say a complaint gets past these hurdles. It's admissible. What happens next? What's the commission's process?
Section 4, starting with Article 48, describes the procedure. Once a petition is deemed admissible, the Commission typically requests information from the government of the state involved. Based on the information from both sides, and potentially its own investigation, which could include an on-site visit to the country the Commission works, to determine if the facts tend to establish a violation.
And what's the goal at this stage?
A primary goal throughout the process is to try and facilitate a friendly settlement between the petitioner and the state. The Commission places itself at the disposal of the parties to reach a solution based on respect for human rights. If the case involves particularly urgent or serious violations, the Commission can move more quickly into the investigation phase. The Commission procedure emphasizes trying for a friendly settlement.
What if a friendly settlement doesn't work out?
If no settlement is reached, then Articles 50 and 51 kick in. The Commission draws up a preliminary report setting out the facts and its conclusions. This report, which might include dissenting opinions from commissioners, contains proposals and recommendations for the state to remedy the situation.
And the state gets a chance to respond.
Yes. The report is sent to the state, which is usually given a specific time frame, often 3 months, to either comply with the recommendations or, alternatively, the state or the commission can decide to submit the case to the Inter-American Court.
What if the state does nothing? Doesn't comply, doesn't send it to the court?
If, after the prescribed period, the matter hasn't been settled and hasn't been submitted to the court, the Commission can then, by an absolute majority vote of its members, issue its final opinion and conclusions on the case. It reiterates its recommendations. If the state still doesn't comply within a further specified period, the Commission can then decide, again by majority vote, whether to publish its report.
Publish it, making it public.
Exactly. Publication is a significant tool of pressure. It brings the state's non-compliance into the open before the OAS and the international community.
Okay, that covers the Commission's role in handling petitions. Now let's turn to the other key organ, the Inter-American Court of Human Rights.
Right, the court. Described in Chapter 7, Section 2, it's composed of 7 judges, Article 52. They have to be jurists of the highest moral authority with recognized competence in human rights law, nationals of OAS member states, and qualified to hold the highest judicial offices in their own countries.
And like the commissioners, they're independent.
Yes, they serve in their personal capacity, absolutely independent, and no 2 judges can be nationals of the same state. The court needs 5 judges present to form a quorum, Article 56. Article 55 has rules about judges from the state involved in a case participating and appointing ad hoc judges if needed. And importantly, Article 60 says the court draws up its own statute and rules of procedure. The current rules date from 2009. The Inter-American Court of Human Rights, its composition and operating rules are key structural elements.
Okay, now, a really crucial question. Who can actually bring a case before the court? Can the individuals or NGOs who started the process with the commission take their case all the way to the court themselves?
This is a critical point about access, governed by Article 61, and the answer is no. While individuals and NGOs have the right to lodge petitions with the commission, only the states parties to the convention and the commission itself have the right to submit a case to the court for a binding judgment.
So individuals rely on the commission to champion their case.
Essentially, yes. If a friendly settlement isn't reached and the state doesn't resolve the issue after the commission's report, the individual petitioner depends on the commission deciding to refer the case to the court. Article 57 says the commission shall appear in all cases before the court.
Has the commission's practice changed over time?
It has evolved, yes. In earlier years, the commission exercised more discretion about which cases to send. In more recent times, the tendency has been for the commission to refer almost all admissible cases that aren't settled to the court, acting more like a gateway. Its level of active participation in the court proceedings themselves has also varied. But remember the key point. Only states, parties, and the commission can submit a case to the court.
Okay, and for the court's judgments in these contentious cases to actually be legally binding on a state, is simply being a party to the convention enough?
No, and this brings us back to that extra layer of complexity we flagged earlier. It's laid out in Article 62. For the court's contentious jurisdiction, its power to issue binding rulings in cases against a state to apply, that state party must have made a separate, specific declaration recognizing the court's jurisdiction as compulsory.
A separate declaration?
Yes.
Oh.
A state can ratify the convention itself, but still choose not to accept the binding jurisdiction of the court in contentious cases unless it makes this additional declaration. And that declaration can be made unconditionally, or it can be conditional, for example, based on reciprocity with other states, or limited to a specific time period, or even limited to certain types of cases.
So it's quite fragmented.
It reflects the pragmatic development of the system, accommodating different levels of state commitment, but it's crucial to remember the court's contentious jurisdiction requires that specific recognition of jurisdiction by the state party involved.
If the court does have jurisdiction and finds a violation, what can it order the state to do? What remedies can it provide?
Article 63 covers remedies. If the court finds a violation, paragraph 1 says it can rule that the injured party be ensured the enjoyment of his right or freedom that was violated. This might involve ordering the state to take specific actions to stop the violation and restore the right.
Can it order compensation? Money.
Yes. Article 63(1) explicitly states the court can rule that the consequences of the violation be remedied and that fair compensation be paid to the injured party. Compensation is a key remedy available. The court's remedies include restoration of rights and financial compensation.
What about urgent situations? Can the court act quickly to prevent harm?
Yes, Article 63, paragraph 2, gives the court a very important power to adopt provisional measures in cases of extreme gravity and urgency, and whenever necessary to avoid irreparable damage to people. This is a protective measure.
Can it do this only for cases already before it?
No, it can order these measures for cases it's currently considering, or even for matters not yet submitted to it if the commission requests it. So provisional measures are a vital tool for urgent protection, used in situations of extreme gravity and urgency to prevent irreparable damage.
And once the court issues a final judgment, are states legally obligated to follow it?
Yes, Article 68 makes this very clear. States parties to the convention undertake to comply with the judgment of the court in any case to which they are parties. This includes complying with orders for specific actions or paying any compensation awarded. State compliance with judgments is a treaty obligation.
Does the court have any other roles besides deciding these contentious cases, like interpreting the convention more generally?
It does, yes. Article 64 gives the court significant interpretative authority through its advisory jurisdiction. OAS member states and certain OAS organs can consult the court for authoritative rulings on how to interpret the American Convention, or indeed other human rights treaties applicable in the American states. States can also ask the court to clarify the meaning or scope of its own judgments in contentious cases that affect them. This advisory role is important for developing a common understanding of the law.
And the court's judgments in contentious cases, are they appealable?
No. Article 67 states clearly that the judgment of the court shall be final and not subject to appeal. Article 66 requires the court to give reasons for its judgments, and judges who disagree can append separate or dissenting opinions, but the final decision stands. Court judgments are final.
Okay, this is where it gets, well, really interesting, doesn't it? Seeing how the court has actually applied all these principles in practice, especially when dealing with those, systemic, extreme violations that have unfortunately been so common in the region's history.
Exactly. The jurisprudence, the case law, that's where the system really comes alive. And looking at some key judgments shows how the court has tried to respond to these profound challenges. And, the Inter-American Court has gained a reputation internationally for being quite creative, quite progressive, particularly in tackling really difficult issues like forced disappearances, and also in developing pretty robust standards for reparations, often working in very challenging environments where states might have been resistant or even incapable.
Let's start with that really famous case, the one that kind of put the issue of disappearances firmly on the international human rights agenda.
You must mean the Velazquez-Rodriguez case. Judgment delivered in July 1988 against Honduras. The facts were harrowing. Manfredo Velazquez, a student, was allegedly snatched off the street by state agents in Honduras, detained without a warrant, likely tortured, and then forcibly disappeared, meaning his whereabouts became completely unknown, the state denied holding him, he vanished without a trace. His family initiated domestic legal proceedings, habeas corpus, criminal complaints, but they all failed. No answers, no justice. Eventually, the commission referred the case to the court. Honduras had ratified the convention, and importantly, it had made that declaration accepting the court's jurisdiction. So the Velazquez-Rodriguez case became foundational for how the system addresses disappearances. And the court, in this case, didn't shy away from confronting the practice head-on. It acknowledged that while disappearances weren't new, the sheer systematic and repeated nature of them in Latin America during that era had become a defining, brutal political reality. The court felt it had to address it coherently.
So how did the court legally define or characterize the violation of disappearance using the rights in the convention?
The court found that a single act of forced disappearance actually breaches multiple specific rights protected by the convention, all at the same time. The arbitrary detention, the kidnapping element, clearly violates Article 7, the right to personal liberty. The isolation, the frequent torture, the cruel and inhuman treatment inherent in being held secretly that breaches Article 5, the right to humane treatment and personal integrity.
And often these disappearances ended in death, right?
Tragically, yes. Because these disappearances frequently resulted in secret extrajudicial killings, they also constitute a violation of Article 4, the right to life. And beyond these specific articles, the court stressed that the very practice of disappearance strikes at the core of fundamental human dignity. So remember, forced disappearances were found to violate the right to life, Art 4, humane treatment, Art 5, and personal liberty, Art 7.
But I remember you saying earlier that the court also found a violation of Article 1.1, that general obligation to respect rights, even though the commission hadn't specifically argued for it. How did the court justify bringing that in?
Yes, that's a really crucial aspect of the judgment, highlighting the court's authority and the fundamental importance of Article 1.1. The court noted the commission hadn't pleaded it, but it invoked the legal principle ira novit curia.
Which means?
It literally means the court knows the law. It's a principle allowing an international court, like the Inter-American Court, to apply the relevant legal provisions to the facts of a case, even if the parties themselves haven't specifically invoked those provisions, as long as the underlying facts are there. The court stated that Article 1.1, the obligation to respect and guarantee rights, is the generic foundational basis for all the rights in the Convention. Therefore, any violation of a specific right, like Article 4, 5, or 7, must also constitute a breach of this overarching fundamental duty under Article 1.1. So using a Euro curia, the court found a breach of Article 1.1.
And why is linking the specific violations back to Article 1.1 so important legally? What does it achieve?
It's absolutely essential for establishing state responsibility under international law. Article 1.1 is what charges states parties with that core duty to respect and guarantee the convention rights. This means, the court explained, that any impairment of those rights that can be attributed under international law to the action or omission of any public authority, any state agent, any branch of government constitutes an act imputable to the state.
So the state is responsible for what its agents do.
Yes. The state assumes international responsibility for the acts and omissions of its agents, even if those agents were acting outside their authority or violating domestic law. Article 1.1 makes the state accountable. The court powerfully stated that human rights protections exist to affirm the inviolable attributes of the individual, these individual domains that are superior to the power of the state. State responsibility flows directly from that core obligation in Article 1. The court also elaborated on what it called the second obligation within Article 1, the state's positive duty to ensure the free and full exercise of convention rights. This isn't just a negative duty to refrain from violating rights, it's a positive duty for government agencies to take steps to guarantee those rights.
And if they fail in that duty?
The consequence of breaching this duty to ensure is clear. The state must prevent violations. And if a violation is proven, the state must not only try to restore the violated right, if possible, but also provide adequate compensation for the damages caused. This duty covers responsibility for direct actions by state agents and for failures to act omissions when the state had a duty to protect rights, like failing to investigate abuses properly. So states have this broad obligation: ensure rights, prevent violations, investigate, restore rights, and provide compensation. The court was also careful to distinguish this Article 1 obligation from the Article 2 obligation. Article 2 is about making sure domestic laws comply with the convention. Article 1, on the other hand, makes a public official's act that violates a convention right directly illegal under international law, regardless of whether it also broke domestic law. And finally, related to the duty to ensure, the court stressed the state's legal duty to use all means at its disposal to seriously investigate human rights abuses that occur under its jurisdiction, and to rectify those breaches. In the Velázquez-Rodriguez case specifically, the court found that the legal procedures in Honduras, while existing on paper, proved completely ineffective in practice. They failed to investigate the disappearance, failed to punish those responsible, and failed to ensure compensation, thereby breaching the state's fundamental duties under Article 1.1. States have a positive legal duty to investigate and remedy human rights abuses.
Wow. That judgment sounds incredibly significant, setting down these core principles of state responsibility for something as horrific as disappearances.
It was, and it remains a cornerstone of inter-American jurisprudence. It was a powerful statement for victims and their families, and a really meaningful development in international law, pushing for accountability and remedies. And on that point of remedies, it's worth repeating that the American court has genuinely been a leader in awarding reparations for violations.
Even in difficult circumstances.
Yes, despite the challenging context, widespread abuses, sometimes limited state resources, or political will, the court developed a pragmatic but principled approach to awarding reparations, including monetary compensation, rehabilitation measures, public apologies, and guarantees of non-repetition. And significantly, unlike some international bodies where compliance is patchy, OAS states have, for the most part, actually paid the reparations ordered by the court. Reparations for victims is a really key, practical outcome of the court's work.
Okay, let's look at those other two cases you mentioned, the ones that came shortly after Velázquez-Rodriguez, and explored some of the procedural issues like domestic remedies and proving these difficult cases.
Right, there was the Godinez-Cruz case, judgment in 1989, also against Honduras. This involved the disappearance of Sol Godinez-Cruz, who was a school teacher. Similar pattern: disappearance, ineffective domestic remedies. The commission alleged violations of Article 4 life and Article 7 liberty and asked the court for remedies, including compensation. That's the Godinez-Cruz case. And the other one was the Ferran-Garbi and Solis Corrales case. This involved two Costa Rican nationals, Francisco Ferran-Garbi and Yolanda Solis Corrales, who vanished while traveling through Honduras. Again, the commission took the case to the court, alleging violations of Articles 4 life, 5, humane treatment, and 7, liberty, the Ferran-Garbi and Solis Corrales case. So these cases continued to grapple with disappearances.
And in both Godinez-Cruz and Ferran-Garbi Solis Corrales, Didn't Honduras argue that the court shouldn't even hear the cases because the families hadn't exhausted all the domestic legal options?
Yes, that was a key preliminary objection raised by Honduras, in both cases the failure to exhaust domestic remedies. This brought the rules in Article 46 squarely before the court again.
And how did the court deal with that argument?
The court built on its earlier jurisprudence. It reiterated the basic rule. You normally have to exhaust domestic remedies first, Article 46. But it also reaffirmed the state's corresponding obligation under Article 25 to provide effective domestic remedies. Remember, Article 25 is that crucial right to judicial protection and effective recourse.
So the remedies have to actually work.
Precisely. And the court then applied the exceptions in Article 46(2) to the specific context of disappearances in Honduras at that time. Honduras argued that remedies like habeas corpus were technically available, but the court reasoned that habeas corpus becomes ineffective in practice when dealing with clandestine detentions by state officials because the whole point is you don't know where the person is being held. If you can't specify the place of detention, as often required by habeas corpus procedures, the remedy is illusory. So, ineffective domestic remedies like habeas corpus when the location of detention is unknown can trigger the exceptions in Article 46.
What else rendered remedies ineffective?
The court went further. It held that if there's evidence of a governmental practice of disappearances, or the government tolerates such practices, that situation also renders domestic remedies generally ineffective for victims of that practice. Why? Because it shows the state itself is either involved or unwilling to act, making pursuit of domestic justice futile. This evidence of state practice of violations can render domestic remedies ineffective under Article 46(2). The court pointed to the evidence of widespread illegal detentions and the demonstrated lack of effective remedies in Honduras during that period, illustrating how state action or inaction can completely undermine the rule of law domestically.
These cases also had to grapple with the sheer difficulty of proving something like a disappearance happened, especially when the state might be hiding evidence. What did the court say about the standard of proof needed?
This was a major issue, particularly in the Ferrin-Garby and Solis-Corrales judgment. The commission argued that given the context a government policy or tolerance of disappearances, suppression of evidence, it should be possible to prove an individual disappearance using circumstantial evidence and logical inferences. Otherwise, they argued, proving these specific cases would be impossible.
And did the court agree?
Yes, the court accepted this argument in principle. It acknowledged that the standard of proof in international human rights proceedings isn't, and shouldn't be, the same as the often very strict beyond a reasonable doubt standard used in domestic criminal trials.
So what standard did it apply?
The court stated that the standard must reflect the seriousness of the charge against the state, but it cannot be so high as to make proving violations impossible, especially when the state often controls access to the evidence. The evidence presented, whether direct or circumstantial, must be capable of establishing the truth of the allegations in a convincing manner. So, the standard of proof is convincing evidence, which can include circumstantial evidence and inferences, and critically, the court reiterated why the standard is different. It stressed again that the objective of international human rights law is fundamentally different from domestic criminal law. The goal isn't primarily to punish the state as if it were a criminal defendant. The objective is to protect the victims of human rights violations and to provide reparations for the harm they suffered. The objective of international human rights law is victim protection and reparations, not punishment of the state. So, applying this, the court found in Ferrin-Garby Corrales that the evidence did convincingly establish the existence of a repressive practice of forced disappearances carried out or tolerated by Honduras during that period. This practice itself was a violation. The court said this proven practice could create a legal presumption that, if combined with other corroborative evidence linking a specific person to that practice, might be enough to find they were a victim.
But the practice alone wasn't enough.
Not quite enough in these specific cases, the court found. The evidence of the general practice, without sufficient additional corroborating evidence directly linking Ferrin-Garby and Solis-Corrales, or Godinez Cruz in his case, to that practice, wasn't enough to meet the convincing standard for finding they specifically had been disappeared by the state. So while accepting circumstantial evidence, the court still required a sufficient link.
Okay, so let's quickly recap the key lessons from this jurisprudence section, especially for listeners studying this. Velázquez-Rodriguez is foundational. Disappearances violate specific rights, liberty, humane treatment, life, and the core duty in Article 1.1. This anchors state responsibility, the duty to respect, ensure, investigate, and provide reparations. Then Godinez Cruz and Ferengar Corrales built on this, really clarifying those crucial exceptions to the domestic remedies rule in Article 46.2 when national systems fail, and setting the standard of proof for human rights cases, convincing evidence, allowing circumstantial proof, always remembering the goal is victim protection and reparations. These cases are really landmark rulings.
Absolutely. They show the court adapting the convention's text to address the grim realities faced in the region, developing principles with lasting impact.
Now, shifting gears slightly, beyond these individual contentious cases that go to the court, the Commission has that other major tool we talked about earlier, the country reports.
Yes, that power stemming from its original mandate, allowing the Commission to investigate and prepare comprehensive reports on the overall human rights situation in any OAS member state. These reports are crucial for shining a spotlight on problems, bringing them to the attention of the OAS General Assembly, other states, and the international community. And they are publicly available, usually on the Commission's website, a valuable resource. The country reports remain a key function of the Commission.
Let's use Colombia as an example. It seems the Commission has reported on Colombia quite extensively over the years.
Colombia is indeed a powerful, albeit tragic, case study of the kinds of long-term, complex challenges the system engages with. The Commission has produced numerous reports on Colombia, spanning decades from the 1980s right through to recent years. These reports offer incredibly detailed insights into a situation marked by protracted internal armed conflict, large-scale violence involving various actors, and deep-rooted structural problems. Just to give a sense, the summary of a 2003 report described the violence as long-standing, complex, and linked to profound social inequalities. It talked about instability affecting democratic institutions and noted the state's persistent failures to fully eradicate violence and assert the rule of law across the entire territory. It acknowledged the path to peace was incredibly difficult, requiring extraordinary efforts.
And the earlier reports, say from the 80s, during peak conflict periods, what did they find?
Those reports painted a very grim picture. For instance, the 1981 report covering the presidency of Turbe Ayala when the state was battling various guerrilla groups was damning. The Commission, having been invited to visit, found that mass-scale torture was tolerated, no measures were taken to prevent and repress it. It documented mass arrests, often based on flimsy evidence, estimating over 60,000 arrests in just 1 year, and concluded that widespread mistreatment and torture were common practices by security forces operating under emergency decrees. Then, under the next president, Bettencourt, 1982-1986, the dynamic shifted somewhat. The executive tried to distance itself from the military's clandestine operations and pursued peace talks with some guerrilla groups, like FARC and M19. But paradoxically, this period saw a significant growth in the power and brutality of right-wing paramilitary groups.
Why was that?
These groups, often linked to powerful landowners, parts of the security forces, and emerging drug traffickers, violently opposed any peace settlement with the left-wing guerrillas. They actively resisted efforts to restore the rule of law in areas they controlled. Clandestine operations, assassinations, massacres continued, targeting suspected guerrilla collaborators, left-wing politicians, trade unionists, and human rights defenders. There was also a perception that amnesty laws favored guerrillas, fueling resentment. Groups like ACD-GAM formed explicitly to support these violent paramilitaries. Meanwhile, on the left, the Union Patriotica, UP, a political party formed partly by demobilized FARC members and other left groups after a truce, tried to participate in politics.
And this volatile mix led to horrific events like the Palace of Justice siege.
Exactly. The 1985 seizure of the Palace of Justice in Bogota by the M19 guerrilla group and the subsequent bloody storming by government forces resulted in over 100 deaths, including nearly half the Supreme Court justices. It was a national trauma. In the aftermath, the right-wing paramilitary groups, often acting with alleged complicity from parts of the state, intensified their systematic extermination campaign against the UP, assassinating thousands of its members over the following years, driven by fears of the left gaining political power and alleged links to active guerrillas. This violence continued to escalate dramatically under the next president, Barco, 1986-1990. This was also when the major drug cartels, like Medellin and Cali, became incredibly powerful, sometimes taking over paramilitary groups, corrupting politics, and investing heavily in legitimate businesses to launder money. The government responded with states of emergency, new specialized public order courts targeting terrorism and drug trafficking, restrictions on habeas corpus, and sometimes security forces were implicated in joint operations with paramilitaries against both cartels and guerrillas. It was an incredibly complex, multi-sided conflict.
The Commission's 1981 report, looking back, offered a kind of broader diagnosis of Colombia's situation then.
Yes, Beyond the specific violations, it painted a stark picture of what it called collapsing structures: economic, political, social, and moral. It observed that the very exercise of fundamental rights was suffering enormously. Government efforts, even if well-intentioned at times, were consistently undermined by these powerful opposing groups, guerrillas, paramilitaries, drug cartels, who simply did not share or respect the basic values of the rule of law. The report highlighted the immense difficulty of building a human rights culture in such a context, noting the shocking contrast between areas of economic prosperity and deep, persistent poverty and inequality. It really showed how a state, even one formally committed to democracy, could be paralyzed by violence and the power of non-state actors. Now, amidst this crisis, there were also significant attempts at social reconstruction and creating new institutions to try and address the situation. There were renewed negotiations with various armed groups aiming for demobilization and political inclusion. New state bodies were created specifically focused on human rights, like the Office of the Presidential Advisor for Human Rights in 1987, a civilian prosecutor to oversee military and police forces, and an Office of the Attorney Delegate for Human Rights tasked specifically with investigating grave crimes like genocide, disappearances, and torture.
But even with these reforms, the violence didn't just stop.
No, tragically not. The cycle continued. The late 80s and early 90s saw horrific assassinations, including 3 presidential candidates between 89 and 90, and the attorney general murdered in 88. Narco-terrorism by the cartels, particularly Pablo Escobar's Medellin cartel, terrorized the country. Under President Gaviria from 1990, there was some recovery of stability. Significant pacification efforts led to the demobilization of several smaller guerrilla factions. A major achievement was the adoption of a new, more progressive constitution in 1991 through a specially elected constituent assembly. However, even that process had complications. A transitional legislative body ended up converting some exceptional presidential emergency powers into regular law, raising human rights concerns about excessive state power, although the new constitutional court later struck down some of these measures.
And the efforts towards peace and reconciliation continued under later presidents, too.
Yes, President Samper and then Pastrana continued efforts. Pastrana famously established the Zona de Distensión, a large demilitarized zone in the south, in 1999 to facilitate peace talks with the largest guerrilla group, the FARC. This showed some promise for a while, but ultimately broke down.
You mentioned earlier that certain crimes were excluded from amnesty in these processes?
Yes, and this is a really important point, particularly relevant when we talk about social reconstruction later. In the legal frameworks developed in Colombia over the years for peace processes and reconciliation, certain extremely serious crimes are explicitly excluded from any possibility of pardon or amnesty. This includes forced disappearance, forced displacement of populations, genocide, and torture. These are considered international crimes or grave human rights violations that cannot be amnestied under international law principles that the inter-American system has strongly upheld. The specific laws, like Law 418, which was later amended by Law 782, set out conditions for ending criminal procedures for individuals involved in the conflict who confess to political crimes or related common crimes, weren't previously convicted, and participate in demobilization programs. Those who benefit can't be prosecuted again for those same facts. But this legal framework always has to be understood in light of that crucial exclusion. The most serious human rights violations are not eligible for these benefits.
But there was a setback around 2002.
Yes, a major upsurge in violence around 2002 led to the collapse of the Pastrana-FARC negotiations at that time. And even when demobilization processes have occurred, critics have often pointed to significant challenges in effectively reintegrating former combatants back into civilian life and providing security guarantees. Fast forward to the Commission's 2013 report. By then, new peace negotiations, particularly with the FARC, were underway in Havana. The Commission's report addressed the state's ongoing obligations regarding past, present, and future violations. For the past, it strongly reiterated that serious violations cannot go unpunished. The state has an inescapable duty to investigate, prosecute, and punish those responsible. For the future, the report emphasized that any final peace accords must fully comply with international human rights law, ensure equality and non-discrimination for all victims, strengthen protection mechanisms, and guarantee victims effective access to comprehensive redress encompassing truth, justice, and reparations. Remember those key concepts. Impunity must be fought. Truth, justice, and reparation are essential. So, the Commission's role through decades of reporting on Colombia has been multifaceted. It documented the horrific reality analyze the complex causes and dynamics, and consistently push the state to develop legal frameworks for peace and demobilization that respect international human rights standards, facilitate meaningful truth and reconciliation, and prioritize the rights of victims, especially their right to reparations. And while the path has been incredibly difficult, remember the 2016 referendum narrowly rejected the initial FARC peace deal. Though a revised accord was later implemented, the situation has evolved significantly, due in no small part to the sustained attention and pressure from the inter-American system, alongside the efforts of Colombian civil society and state actors themselves, though of course huge challenges remain.
These country reports, using Colombia as such a stark example, really drive home the sheer scale and depth of the human rights problems that the inter-American system is designed to confront.
They absolutely do. They show how the system grapples not just with individual cases, but with these deeply entrenched situations involving widespread violence, state weakness or complicity, powerful non-state actors, and the difficult long-term process of trying to build peace and establish the rule of law.
Okay, building directly on that Colombia example and also linking back to the jurisprudence we discussed earlier on disappearances and state responsibility, let's look specifically at how the court and commission together have developed principles for what you might call social reconstruction after armed conflict.
This is a really important area where you see both the court, through its judgments, and the commission, through its reports and thematic work, collaborating and developing a significant body of principles. Their work focuses on guiding societies as they try to transition away from periods of widespread violence and atrocity towards peace, democracy, and the rule of law.
What are the main themes or goals guiding this work?
The central challenge, and therefore the guiding theme, is how to balance the practical, urgent needs of rebuilding a functioning civil society and state institutions with the fundamental legal and moral requirements to uncover the truth about past violations, ensure justice for those crimes, and provide meaningful reparations to the victims.
And where do the legal principles for this come from?
They're derived primarily from the core inter-American human rights instruments, the OAS Charter, the American Declaration, and for states parties, the American Convention. These are interpreted in light of general principles of international law, especially international human rights law, and, where applicable, international humanitarian law. A fundamental starting point is that human rights obligations continue to apply during armed conflict. They aren't suspended just because there's internal violence. These obligations bind states as international actors and relate to everyone under their jurisdiction. Human rights obligations apply during armed conflict, that's key. From these sources, the court and commission have articulated what you could call foundational principles essential for rebuilding a society after conflict. And they consistently emphasize three pillars: truth, justice, and reparation. These aren't just seen as abstract ideals. They're presented as practical necessities for building sustainable peace, fostering tolerance, restoring faith in the rule of law, and decisively rejecting impunity for past atrocities. Truth, justice, and reparation. These are the foundational principles for social reconstruction.
Okay, let's unpack those. Starting with the right to know the truth. What does that mean in this context?
The right to truth addresses a really pressing need felt intensely by the direct victims, by their families searching for answers, especially in disappearance cases, but also by society as a whole after periods of systematic abuse and state secrecy. The Inter-American Court, in particular, has significantly developed this right, often grounding it legally in Article 25 of the Convention, that right we discussed earlier, the right to judicial protection and effective remedies. The right to truth is strongly linked to Article 25.
How does Article 25 support a right to truth?
The reasoning is that the right to an effective remedy implies a right to know what happened. The court has argued that the right to truth cannot be legitimately restricted by domestic laws or measures, like overly broad amnesty laws that are designed to conceal the past, shield perpetrators, or deprive victims of their right to seek justice and remedies. Article 25 actually compels states to take positive steps. They must ensure avenues exist for seeking and receiving information about violations. They should consider establishing official investigative bodies like truth commissions. And crucially, they must enable effective judicial investigations into alleged crimes and human rights abuses.
And you said this right belongs not just to individuals, but to society.
Yes, that's an important development.
Yeah.
While specific articles like 8, fair trial, and 25 clearly imply a right for next of kin to get facts about what happened to victims and to demand prosecution by the state, consistent with rulings from bodies like the UN Human Rights Committee to the Inter-American Commission and Court, have generalized this into a broader right for society as a whole to know the truth about the aberrant crimes committed during periods of conflict or repression. Society has a right to know the truth about past atrocities.
Why is that societal right to truth considered so important for Reconstruction?
It connects to something quite profound, healing the rule of law itself. In societies emerging from conflict, the legal system, the courts, the state institutions, they're often deeply compromised, perceived as biased or ineffective, maybe even complicit in the abuses. Establishing the truth, openly and officially acknowledged by the state, is seen as part of starting again. It's a way to demonstrate that an impartial, functioning rule of law is genuinely possible now, and that the state intends to represent all its citizens, not just perpetuate the interests of one faction from the conflict. It's a symbolic cleansing in a way.
This emphasis on truth and justice must have implications for things like amnesty laws, which are sometimes used as political tools to end conflicts. Are there limits on amnesty?
Yes, absolutely. The court and commission have been very clear and consistent on this point. Certain categories of crimes, because of their extreme gravity, must not be left unpunished. They are considered imprescriptible offenses under international law principles reflected in the Inter-American system.
Which crimes fall into that category?
The list typically includes crimes against humanity and serious war crimes like political assassinations forming part of a pattern, forced disappearances, systematic rape and sexual violence, forced displacement of populations, torture, other inhumane acts causing great suffering, deliberate military attacks on civilian populations, and the recruitment and use of child soldiers. These imprescriptible offenses cannot be lawfully amnestied. For these types of imprescriptible offenses, states parties to the convention have a strict, non-derogable duty under international law to investigate, prosecute, and punish those responsible. This duty applies regardless of whether the perpetrator was a state agent or a member of a non-state armed group. And crucially, the state bears the primary burden of initiating and carrying out these investigations and prosecutions. It can't just leave it up to the victims or their representatives to try and pursue justice on their own. States have a positive duty to investigate and punish imprescriptible offenses.
Which articles support this duty?
The Court and Commission draw this duty from several convention articles read together, particularly Article 1.1, the duty to respect and ensure rights. Article 2, duty to adopt domestic legal measures. Article 8, right to a fair trial, including access to justice, and Article 25, right to judicial protection, effective remedy. They also link it to non-derogable obligations under international humanitarian law, like the Geneva Conventions, which correspond with the non-derogable rights provisions in IPHR Articles 27 and 29. So Articles 1.1, 2, 8, 25, 27, and 29 are all relevant here. So the fundamental principle that emerges from the jurisprudence is this. Any amnesty law, to be compatible with the American Convention, must be carefully limited. It might potentially cover purely political crimes, or maybe common crimes clearly linked to the political conflict, but only those that do not constitute serious human rights violations or international crimes. Amnesties cannot cover serious human rights violations.
Okay, that's clear on truth and justice. What about the third pillar, reparations for victims? How central is that to social reconstruction?
Extremely central. The victim's right to obtain reparations for the harm suffered is a major principle running through the court's judgments and the Commission's recommendations in post-conflict or transitional contexts. There are really two key reasons for this emphasis. First, providing reparations affirms the legal status and dignity of the victims as citizens whose rights were violated, offering some measure of recompense for the profound harm they endured. Second, effective reparations programs are seen as vital for rebuilding trust between citizens and the state, demonstrating that the legal system can provide redress after it failed so badly during the conflict. Victims have a fundamental right to reparations.
And what forms can these reparations take? Is it just about money?
No, it's much broader than just financial compensation, although that's often part of it. The court emphasizes that remedies must be diverse and tailored to the specific harm suffered. They can include measures like medical and psychological rehabilitation for survivors of torture or trauma, restitution, such as the return of land or property that was illegally seized, symbolic measures like public apologies or memorials, and guarantees of non-repetition, meaning steps the state must take to ensure the violations don't happen again. The key is that remedies must be adequate, effective, and proportionate to the gravity of the violation and the harm caused. Immediate restoration of liberty is, of course, the primary remedy for unlawful detention. And the next of kin of those killed or disappeared have a clear right to compensation. Diverse and proportionate reparations are essential.
And how does this connect back to the societal right to truth?
There's a strong link. Reparations, especially symbolic ones, contribute to society's understanding of the truth. Things like public acknowledgments of responsibility by the state, the recovery and preservation of the memory of victims, building memorials, and ensuring the historical truth about the conflict and its atrocities is taught. These are all forms of reparation that also serve the collective right to know and remember. Of course, other practical aspects of Reconstruction are also important, like effectively disarming armed groups and finding ways to reintegrate former combatants back into society safely and productively, but always within a framework that ensures accountability for the most serious crimes.
So, taking all this together, the focus on truth, the limits on amnesty, the duty to prosecute grave crimes, the emphasis on diverse reparations for victims, would you say the inter-American system has developed a distinct jurisprudence of social reconstruction?
Yes, I think that's a fair assessment. The consistent work of both the court and the commission, particularly in addressing the legacies of conflict in countries like Colombia, Peru, Guatemala, El Salvador, and others, dealing with transitional justice issues, amnesty laws, and reparations claims, really does amount to developing a coherent set of legal principles and standards specifically tailored for social reconstruction in the aftermath of widespread human rights violations. They've articulated, based on the convention and international law, what is required to move forward in a way that respects victims' rights and rebuilds the rule of law, placing truth, justice, and reparations firmly at the center of that process.
We've covered a huge amount of ground today, a really intensive deep dive into the inter-American system for human rights. We've traced its history right back to those early Pan-American ideas, looked closely at the foundational declaration and the crucial American Convention, and unpack the distinct roles and powers of the two key bodies, the Commission and the Court.
And we've seen how they've had to grapple with these incredibly challenging, often horrific realities on the ground, tackling issues like forced disappearances head on, developing principles for state responsibility, figuring out how to handle domestic remedies when they fail, setting standards of proof in difficult contexts, and evolving this important jurisprudence on social reconstruction after conflict. We've highlighted the system's unique complexities, too, those overlapping documents, the different ways states engage with the court's jurisdiction, the commission's important dual mandate.
And the specific rights laid out in the American Convention, including that absolutely critical list of non-derogable rights that can never be suspended.
Exactly. And we've seen through that powerful example of the Commission's long engagement with Colombia just how immense the problems are that the system faces and how deeply intertwined human rights protection is with the broader challenge of building or rebuilding a functioning democratic society governed by the rule of law, especially when emerging from legacies of violence and impunity.
It really brings home the point made in the source material we've been discussing.
That ultimately, protecting the human rights in this region raises some truly profound problems for the institutions tasked with doing it. It demands more than just legal frameworks. It requires a deep, sustained cultural commitment to democracy, to human rights values, working constantly against those powerful legacies of conflict, inequality, and organized crime that continue to pose threats.
So as a final thought for you, our listeners, to maybe reflect on, especially those of you preparing for exams on this topic, consider this question, which encapsulates so much what we've discussed. Protecting human rights in Latin America raises some profound problems for those bodies charged with this task in the inter-American system. How does everything we've explored today, the history, the structure, the case law like Velasquez-Rodriguez, the country reports, the challenges of implementation, how does all of that illustrate those profound problems?
We really hope this deep dive has been helpful in unpacking this complex but incredibly important topic for you. We wish you the very best of luck with your studies and your exams. And remember, this deep dive, drawing on materials made available by the University of London, was brought to you by Sinorbit Academy, Sri Lanka.